Arishan to come and occupy the dais. May I request, may I request the trustee, may I request the trustee of Papu Venugopal Rao Trust to come and occupy the dais. Mr. Mohandas. I request all of you to kindly settle down. Yeah. Esteemed invitees and also the dignitaries on the dais, I have great pleasure on behalf of the Administrative Staff College of India to extend a very warm and cordial invitation to all the distinguished gathering. Our special thanks are due to Sri Anjaney Reddy Garu, who is giving the distinguished oration today, the sixth oration. In the audience, we recognize the very gracious presence of Sri P.S. Ramohan Rao, who gave the fifth oration, former governor and former DGP, Dr. Jitendra, Sri Kamal Kumarji, Dr. Vyas Narayan Rao, our COG member, Mr. P.V. Ramesh, and many other equally distinguished people. The Venugopal Rao oration has become a wonderful tradition. This makes us to take a look at the criminal justice system and what systemic improvements could be brought about for public good and public welfare. In that sense, this lecture generates a number of useful insights, ideas. Last year, the distinguished speaker spoke about the changes which we could bring about in administration of criminal justice without any amendments, within the very scope of what he called the management. These are wonderful takeaways. This year too, we are looking for an equally thought-provoking lecture by Sri Anjaney Reddy Garu, who requires no introduction. Among the police fraternity, he is known as a thinker who always puts not the police cap, but also a thinking cap. He is he conceptualized number of ideas and nurtured them to fruition. And he went into several domains and he made them better. The APSRTC, Tourism Development Corporation, the Police Academy are among the few, apart from the Buddhist Trust in Hyderabad. I have a special bond with him because he was the mentor of the Hyderabad Study Circle at time, which saw the need to foster native Andhra Pradesh born youngsters to groom them into services. I was one such who passed through that portal of Hyderabad Study Circle, which he continues to nourish with passion and made a lot of contribution. With this, I would now request our chairman, Sri Padmanabhai Garu, to kindly honor Mr. C. Anjaney Reddy with a bouquet. I would now request our chairman to give his opening address.
Good evening to everyone, especially to Dr. Anjaney Reddy, who is the main speaker today. and Dr. Mohan Das. I am his patient. Incidentally, I occasionally go to him, So other members of the family of this one, Professor Manimala is there, her husband, Vyas Narayan Rao is here, and very distinguished police officers are here. Mr. Rammohan Rao is here, the governor, the DGP is here. These are the enforcers of law and justice, and other distinguished members here. It's a very warm welcome to you. I don't have much to say, except that we are happy to have Dr. Anjaney Reddy, because by reputation, he is an achiever. He's not a chalta hai type, he's one of the rare species of civil servants. And I was reading here that this Hyderabad study circle, he has been associated for 45 years or 49 years. I always used to claim I spent the largest time in government and on one particular job for about 12 years. But here is one gentleman, of course, he's not in the government, but semi-governmental one, 49 years, my God, that is 4 generations, of people he has must have trained. And he just did not confine himself to police. He went into sports, he went into culture, tourism, so many areas. So we welcome you here. And as far as the gentleman whose birth centenary we are celebrating, actually it's not the birth centenary, it's birth centenary plus 6 years, because he's the 6th, this one. He is also an extraordinary gentleman. I have not seen another police officer who had been given a doctorate, D.Lit, by the Andhra University. The D.Lit of Andhra University is not like the PhDs now. The PhDs are a dime a dozen. But in those days, to have got it, he's a writer, prolific writer, 12 books or something he wrote. He's a researcher. He is an innovator. He wrote in Telugu as well as in English. And what should I say? I mean, he was in forensic, science, the National Institutes of Criminology. He was in the BPRD. He was in the CBI. He was in the IB. I think all facets of police work, he had seen that. So we are celebrating his birth centenary. So that's another good thing. Now, to the topic about this one, many speakers have spoken in the past also on this. I think this is one of the most pressing issues before the country. It's a complex subject because in the delivery of justice, there are so many people involved. The police are involved, the prosecution is involved, and the judges are involved mostly, most importantly, and then the prison system and all that. The whole thing, generally what happens is one points at the other. I have done my job, but the other fellow has not done properly. I tell them that look at ourselves. I mean, you should first see what can be done about ourselves, whoever it is, a policeman or a jailer. Or there is no point in sort of blaming the others. And the procedure itself has become the punishment now. Everybody says, that's what Mr. Rammohan Rao also emphasized the other day. And sometimes they say bail is the order of the day. Sometimes they say jail is the order of the day. You don't know what. And justice has become a matter of joke and phrases, Justice denied is justice. The justice delayed is justice denied. Or justice hurried is justice buried. All types of things, But I read a judgment, Dr. Judge, he was speaking a year before. In the CBI, after having done so many cases, there was a judgment saying that cases held by CBI for the last 20 years or so in Assam, they're all invalid because CBI does not apply to that particular state by the declaration given by the government order. So they said all of them do not exist. I mean, there are orders, people have suffered the jail and all that. No nest, as he said, do not exist. So this is the funny thing, And I find that the weakest link in the entire system is the prosecuting system, the prosecutors. What they do is, this is finding fault after the event. When the case is being investigated, none of them come and help on how you should proceed. By what steps should you take to see that all loopholes are covered, there are no pitfalls anywhere. No, at that time he is somewhere. But when the case is decided, thereafter, when the judge points out, then he says the police have not worked well. So it's a terrible system. So since the DGP is here, the governor is here, I thought I would mention this. So I don't want to elaborate more, but I'm sure Dr. Anjaney Reddy would cover all these aspects. And I wish you a wonderful evening. Thank you very much for being with us.
May I request the chief guest to deliver his oration? I would request the trustee, Mr. Mohan, to my apologies. I would request him to speak a little about the family and its connection to this oration. This I regret the.
Thank you for this
omission.
opportunity. Thank you very much. But as it happened, I was supposed to be a silent spectator, observer. But I am very glad that Mr. Anjaney Reddy finally acceded to my request, and he said, I'll finally talk. It has been a few years I've been trying to get him on stage. He is a reluctant. But I know. Okay. I know. No. No, it won't be. That's exactly why. Thank you very much, sir, for acceding, and please go ahead.
Our old boss, Ram Mohan Rao Garu, and many of my old colleagues, both serving and retired. Dr. Mohan Das was insistent that I should come and speak this time, because last year also he wanted me to do that, but I couldn't. It is 22 years since I retired from service. So my knowledge in a way is dated. Now that I have agreed to do this, I had to read all those things again and again. I've been on this job for the last 1 month because we lost track of it, the things as they were then and now the new. The new laws. Before that, I would like to say a few words about Venugopal Rao Garu. I first met him in 1968 when I was in practical training in Kakinada. His brother was a doctor there. He was visiting him. Those days he was already joint director in IB. So police officers told me that a senior officer visiting Kakinada. Those days, our instructions were, if there is a senior officer visiting, you should go and call on them unless they don't want to meet you. So I took permission to see him, and he received me at his brother's place and spoke to me for about 10 or 15 minutes. I still remember two things he told me. First thing, he said, IPS officers, once they're out of the academy, they don't read much. This is what he said. And then he also said, they don't keep in touch with the day-to-day policing also. They don't even read the journal. Those days, IB used to publish this journal. I always remember that. Then he gave me a few, spoke to me about a few things. And later, I met him from time to time because he was a great friend of my father-in-law, Mr. Ramchandra Reddy. They were together in Madras University. Later, they were colleagues in police department. So he was a frequent visitor to his place. So I used to meet him. During those meetings, several things he would talk about and very interesting things. He and Mr. Victor, they used to tell us lots of stories about old Hyderabad, and then they all came to Hyderabad together. Mr. Ramchandra Reddy, Venugopal Rao Garu, and Mr. Victor, all the three of them were deputed by the Madras government, those days Andhra, to Telangana, Madras presidency. Subsequently, when I was posted as director of the AP Police Academy, I noticed Mr. Venugopal Rao was listed as one of the guest speakers there. I thought it was atrocious because he was a very well-known officer even by then, and by then he was retired. I took it to the government and then said he should be designated as Professor Emeritus, not as a guest lecturer for police. Government immediately agreed and designated him as Professor Emeritus of AP, our AP Police Academy those days, now Telangana Academy. During this time and later, I read some of his books, and at least 10 of them are very well-known books. Many of them are on police work. Some of them are creative writing also. Police Venkataswamy Kathalu, of course, is best known. Mr. Sitaram Rao is not here, but those days, it was a very popular series in the Police Venkataswamy Kathalu. In fact, we were requesting some of our short filmmakers to make a serial of this. Police Venkataswamy Kathalu, it would make very good, Then, among the many books he wrote, about almost 13 books on police and about 6 or 7 monographs and several other articles and all that. Towards the end of his life, he was writing about the victim compensation, victimology in psychology. It's called victimology. And then he was very keen that something should be done about this. He wrote extensively on victimology also. Apart from this, he also wrote a book on bridge. He called it Varadi Satakam. Bridge is Varadi. So, book on bridge. He was a keen bridge player. In fact, when we renovated our police mess, the bridge room was Mr. Venugopal Rao inaugurated it. And they all used to meet there, Mr. Mahendra Reddy, Mr. Venugopal Rao, Dr. Mohan Das, and Ayyappa Reddy, and a few people regularly they used to meet there. And then they used to play bridge. On that, he wrote a book, 100 stanzas, called Varadi Satakam. Bridge is Varadi in Telugu. It's a play of words. And then this is perhaps the only book in Telugu about any game, for that matter. So let me read out 1 or 2 poems from this. Then we can go into the subject proper. About Bridge he wrote, Lo guttu devuniki eruka, nee guttu parula kanta padaneeku. Lagumu vairula guttunu elagainanu tudaku gelpe lakshyamu. ముక్కలు వచ్చిన చాలదు చక్కగా వాటిని విధాన చాతుర్యముతో లెక్కలు సరిపెట్టుకొనుచు మక్కువతో మరియు విజయ మార్గము వార్ది అన్నాడు. కోపము తగ్గించుకునుము, కోపంబున నీ మెలకువ కూలును విధిగా, తాపం వెన్నడు వలదని తాపసురెప్పుడో నుడివిరి ధన్యులు వార్ది. And people like me, I could never learn this game. My father-in-law also tried to teach me, but I could never learn it. I found it very boring. I couldn't even hold the cards together. So people like me, he wrote a poem on them also. Arambincharu suntalu. Arambinchi త్యజింతురు అల్ప ప్రాణులు. ఆరంభించిన విడువరు తీరమున చేరు వరకు ధీరులు వార్ది అని. So I come perhaps in that category, but I never learned this. Then he also wrote a poem on his own death, actually. We, in fact, printed it even before he died and kept it because we knew his days were coming to an end, Mohandas, and we both knew. He wrote a nice poem on his own death, and that we distributed on the day of his 11th day ceremony. This is in the past when I was a child, and my mother told me, told me of the next day's journey. I was thrilled, I was awake in the long silent night with joyous anticipation of new places and new enchantments. The poem goes on like that. And the last part of the poem is, I am now full of years. Now I am full of years, joys and sorrows, and unresolved angers. My mother's voice is stilled. My father will not see me off at the ill-lit station. Yes, I know of tomorrow's journey. This time, no chugging train will take me along the green swaying fields, nor a throbbing plane across the blue skies. But I lie awake through the long silent night in rapturous anticipation of uncharted seas, distant galaxies, new climes, and new enchantments. This poem, I sent it to a literary magazine through a friend of mine. They asked me whether it was published earlier. They said, no, it was not published. Then they published it. Subsequently, it was published by Swatantra or some other magazine also here. So this shows how creative he was, both in Telugu and English. So with all this, now I must confess, I proposed his name and the name of Justice Chinnappa Reddy to Andhra University for this honoris doctorate, honorary doctorate. It was very well received, but some professors objected to this. How can you do this? How can you give it to a policeman? These are natural, usual prejudice against all police officers. Then Mr. Gopal Krishna Reddy, then the Vice Chancellor, he said, how many professors are there who have written even half as much as he has done? There were nobody. And then finally they agreed. So Justice Chinnappa Reddy and Venugopal Rao Garu both are great friends and colleagues in Madras University also. They both were honored by Andhra University with honorary doctorate. Now, today's subject is something very of interest to Venugopal Rao Garu. He wrote about criminal justice system long ago, but almost, one of his first books about this criminal justice system, and his writings on victimology. Both were subjects of interest for him. So I thought we should revisit this criminal justice system. Criminal justice system, Ramohan Rao Garu and we met several people, made presentations to them. We gave a lot of information to people, including Justice Malimat or Ramohan Rao Garu sent it. In fact, I met the Law Commission Chairman for amendments of CRPC. I also met the Secretary Home. That Secretary Home didn't even know there was a proposal like that, It was some gentleman from Maharashtra was the secretary. We did all that and then we became frustrated. The last article I wrote on this was in 1995, saying these colonial laws at least should go with the century, the end of the century. They didn't go, they continued. And today, 25 years later, they revised. But I don't think, any important things are still there. It is in fact, I was very much disappointed when I started reading this, Anyway, we'll go into the subject proper. I'm not all aspects of it I'm not going to speak about because it would be very boring for people who are not police officers. But important things which have now been recognized. And incidentally, victimology at last has been recognized. They say victims should be compensated has now been recognized. Similarly, witness should be protected from all kinds of threats and all. That is also now recognized. It has taken them perhaps, 30 or 40 years of people writing, different people from different places. Finally, these things found place in the Criminal Procedure Code. So I'll quickly go through this. The four pillars of the criminal justice system, as we all know, are the police, the prosecutor, the judge, and the much neglected correctional administration. It's completely ignored. The IPC, Evidence Act, and the CRPC provide the legal framework for the criminal justice system. Before we revisit the CJS, this Criminal Justice CJS, it would help us to recall the historical context in which these laws governing the CJS were brought in. In mid-19th century, there were widespread allegations against the East India Company employees that they were routinely torturing the farmers to collect taxes. The company appointed a 3-member body called the Madras Torture Commission. In 1854, to investigate the allegations of torture and abuse by their native revenue and police officials. They are native officials, people who were harassing them. After 7 months of investigation, the commission released its report in April 1855. Findings included, among other things, these 4 things. 1, the commission received 1959 complaints, with some victims traveling 100 miles to testify before them. They must be from Nellore, it's 100 miles from. The report confirmed that the torture was widely used by the company employees to compel the farmers to comply with the excessive land tax demands. The commission also confirmed that the violence was routinely used to obtain confessions in criminal cases. The report attributed the problem to several factors, among them the unreasonably high tax assessments, low pay of the native employees, and combining police and revenue duties in the same officials. These are the findings of that torture commission. Then, thanks to the Sepoy Mutiny of 1857, the administration of the colony was taken over by the Crown, and a series of laws were brought in. District Police Act 1859, this is what governs Telangana and Andhra even today. That is 2 years earlier than the Indian Police Act. District Police Act of 1859, IPC in 1860, Police Act in 1861, that is from Calcutta, 61, Evidence Act in 1872, and Criminal Procedure Code in 1882. At that point of time, the legal framework these laws created was a great advancement in a country where there was no method in law enforcement, the different communities being governed by different laws and different punishments to different people for the same offense. That is, if a high caste man was guilty of some offense, he would get one punishment, low caste people another punishment. There was an incident in, I don't exactly remember the year, about that time in Pondicherry, which was under the rule of the French. A Brahmin was convicted for murder. The French judge awarded him that, death sentence. Then the whole district, people marched to his bungalow and said, a Brahmin can never be put to death, whatever he is guilty of. The maximum punishment you can impose to a Brahmin is to cut off his pilaka and get stuffed and send him out of that territory. So that is how the laws were. One punishment for Brahmins, one punishment for non-Brahmins, and scheduled castes, for the smallest things also, they were punished with death. So these laws, they were considered great advancement because of a country which was governed by this kind of system earlier. These laws, which have their origins in colonial India, should have been revised immediately after independence. In any case, certainly after the Constitution was adopted in 1950. As more important things occupied the minds of our leaders, CGS was put on the back burner. So over the last 75 years, Republican India was governed by colonial laws. It was Republican India, but it was governed by colonial laws. In fact, I had a presentation, I stopped now making it. The last time I made this presentation was around 2012 or so. Colonial police in Republican India. So at last we have revised versions of these laws with patriotic names. I'm trying to remember these names. I'm not able to, I'm forgetting frequently. Bharatiya Nyaya Samhita, that is IPC. Bharatiya Nagarika Suraksha Samhita, CRPC. Bharatiya Sakshya Adhiniyam, Evidence Act. It's very difficult to remember this. I still remember only CRPC, IPC. However, no attempt has been made to replace the 164-year-old Police Act. The criminal justice system, if you really want to improve it, first the Police Act should go, it should be revised. It should be, new act should come in. In spite of the recommendations of several police and administrative reforms commissions, even the second reforms commission, administrative reforms commission, with Mr. Veerappa Moily as chairman, I was also associated with it. I made a deposition on this also. He recorded it. In fact, he was good enough to say that there is no need to further study all these things. You adopt a Malimat Commission. That's what he wrote in the report. You adopt a Malimat Commission, that's more than enough. That's what Veerappa Moily wrote. But still, government didn't think it necessary. Now they, again, I don't know who they entrusted it to now. One would have expected the government of India to bring in a model police bill on the line suggested by the National Police, third National Police Commission, and insisted on the states enacting their own police acts with appropriate regional modifications. That should have been done. It was not done. In the absence of an act providing for an autonomous and accountable police force, the revision of colonial laws would be incomplete. There is no use blaming the police, there is no use blaming the prosecutors as long as these laws are not revised. Things will continue to be the same. However, let us briefly examine how the revised laws impact CJS. Bharatiya Nyaya Samhita has gone through an elaborate revision, IPC. It has brought into its ambit several modern-day offenses, enhanced fines, prescribed, and gives powers to judicial officers to determine if the terms of punishment should run concurrently or consecutively. Earlier, generally, it used to be concurrently. Now they can make it consecutively also. The Act with 358 sections now is compact compared to its predecessor, which had 511 sections. This can be further compacted by shifting the chapter on election offenses, election-related offenses to the relevant act. There is no need to have them in this in IPC. It can go to the Representation of People's Act or some other relevant act. However, Samhita has not made a beginning. See, this is the major. It has not made a beginning in identifying and categorizing economic offenses and cyber crimes. These are the most important crimes now. Today, police, I think, are spending more than 50% of their time on this economic investigating officers, more than 50% of their time on economic crimes and cyber crimes. And that is not there in the act at all. They have not made any effort to. Recently, there has been a tremendous explosion of these crimes. In course of time, the police will have to devote the best part of their time and energy to investigating these offenses. We can see that even that digital arrest has now become so, everybody knows about digital arrest, still people are getting cheated every day. The Samhita unfortunately carries forward the antiquated, irrational division of offenses into cognizable and non-cognizable offenses. Our Rammohan Rao Garu and I, we requested that they should be called arrestable and non-arrestable offenses. Why do you call them as cognizable and non-cognizable offenses? It is common sense that if an offense is fit to be listed in the BNS, that is IPC, it should be cognizable. Non-cognizable offenses often cause problems for the police, as the complainant might go away with a feeling that the police are not evincing interest in his complaint. He would not understand the niceties of cognizance and non-cognizance. More importantly, an unattended non-cognizable offense might result later in an avoidable cognizable offense. It often happens. Suppose an important man in a village is slapped by somebody. It is non-cognizable offense. But then if it is Rayalaseema, a few days later, you can expect a murder on that score. These kind of things are so they may look prima facie as small offenses, but it can have tremendous effect on the law and order situation. It would have helped if the non-cognizable offenses were treated as summary trial cases. Summary trial offenses, punishable with fine and taking from the accused person a bond of good behavior. This would have served to improve the effectiveness of policing in the area. This is another major problem here. Then one good thing is they have introduced community service in place of punishment. It has been introduced for the first time in this act. Any person who is particularly younger people, a Department of Correctional Services working in close cooperation with the police department, so badly needed for this important function. They have made a provision in the law, but there is no department to improve. Earlier, we used to have a department for Probation of Offenders Act. It was part of the Prisons Department. I understand it was shifted to social welfare. But this is an important thing. We require a separate department for this, and police should be associated with it because it is their problem basically. A Department of Correctional Services working in close cooperation with the police department is badly needed for this important function. Presently, this responsibility is vested in the Social Welfare Department, whose hands are already full with several other programs. Surely this is not one of their priorities. That is about the IPC. Next is Bharatiya Nagarik Suraksha Samhita, that is I call it BNSS or CRPC. One significant improvement is that the police have now to register cognizable cases brought to their notice, irrespective of the jurisdiction of the police station. That's a very good thing. Earlier they would go to Panjagutta, they will say, you go to Himayatnagar will send him to Mushirabad. All that is gone now. You can report it anywhere. And it is for them to send it to the concerned police station. One significant improvement is that the police have to register cognizable offenses brought to their notice, irrespective of jurisdiction. Also, crimes can be reported either in person or online. You can send a message also. They have to register a case. But within 3 days, you should go to the police station and sign it also. That is still there. Preliminary, there is another thing in 178 CRPC, there is a provision for preliminary inquiry also. Election time, you find, lots of complaints against politicians. Most of them have no substance. But then they are registered as cases, and then they say 30% of the legislators have a criminal case against them, 40%. This kind of thing goes on. Actually, most of them are motivated complaints. Today, we can make use of this provision, and we can avoid registering that kind of cases in 178 CRPC. If properly used, if it is properly used, frivolous complaints against politicians can be eliminated. There are, however, fears of scientific evidence being destroyed. If you take 3 days to register a case, and in the meantime, whatever little scientific evidence is there, that will not be there. That is the major disadvantage in this. With regard to collection of evidence, including the evidence of experts, electronic evidence, many useful improvements have been incorporated to make use of available and developing technology. It also makes videography compulsory in certain situations, like seizure, search, this kind of thing, and inspection of scene of offense. All these have to be, you have to take videograph. Digital and electronic documents are admissible as primary evidence. Earlier, it was not admitted as primary evidence. Now it is permitted. In short, an effort has been made to bring technology in a big way into investigation. Now, the responsibility of the police department is now to train these people, our people, to take all these videos and all that and give them equipment and all. It's a big responsibility. This part of the law deserves much better attention than BNSS also introduces elements of witness protection and victim compensation. This is a very important development. Mr. Venugopal Rao would have been happy to see this at last in the law. After some 30, 40 years ago, he wrote about this. This part of the law deserves much better attention than token recognition as it is now. It's possible to divert the fine recovered to a fund to be created at the disposal of the legal services agency. Now the provision in the law is government should create this legal services agency and provide funds. They can never provide funds. So what I am suggesting here is let all the funds which are collected as fines. Now fines have been raised. It is not 50 rupees, 100 rupees, it's 5,000, 10,000, 20,000 like that. So let it be created to this fund so that we don't have to wait for the government every time to say. Otherwise, like any other government schemes, it will also be short of funds. While the new law is progressive in some respects, in respect of the police, it carries into 21st century colonial prejudices of the 19th century. About the police I am talking of, investigators. The investigating officer who records the statements of witnesses cannot take their signatures even now. He can't take their signatures. This has been the bane of our law, as it gives an opportunity for witnesses to resile from their own statements and go unpunished for it. It continues. This is 19th century law. It continues in the 21st century law also. Same thing. Directorate of Prosecutions. It's a matter of some satisfaction that at last one of the major recommendations of the Third Police Commission in regard to the Directorate of Prosecution has found place in the BNSS, that is our new CRPC. Undivided AP was among the first states to implement in earnest under the new law. Under the new law, it is possible to build a hierarchy of professional prosecutors, assistant, deputy, and public prosecutors. We made rules as early as 1990 or so. When I was working in the police academy, one of our judges, Justice Bhavani Prasad was with me. We all sat together and made these rules and got the scheme approved by government. When Mr. Vijay Bhaskar Reddy, a lawyer, he was the chief minister. Samar Simha Reddy was the law minister. They both were reluctant to approve this, saying, they can appoint their own people if such a thing is not there. But finally, both were persuaded to clear this, and they cleared it. It is there. And the next now, after recruiting one batch of assistant public prosecutors, somebody went to the court and then stalled the whole thing. Now I find at last, after some 15 years, the second batch is going to be recruited now. Now, this is the type of thing going on there. The Directorate of Prosecution should be an autonomous and accountable institution. It is not their law, it doesn't say all that. It only says Director of Prosecutions. While it should be under the administrative control, they said it should be under the administrative control of the Home Department. Yes. But it should have a formal nexus with the police department and have the powers to legally scrutinize the evidence collected by the investigating officers in all the cases punishable with 7 years of imprisonment and more. Some what we call grave crimes in police. So they should be associated with the cases right from the beginning, as it is done in the CBI. CBI, it is done like that. He is like a legal advisor to the police. And finally, when the case is charge sheeted, he becomes a prosecutor. And it should be his responsibility to say whether a case is fit to be charge sheeted or requires further investigation. Now it's entirely left to the police. Police is under the government. So there used to be a joke in earlier. Now, if it is a ruling party man, it is grievous hurt. If it is an opposition man, an attempt to murder. This kind of thing used to go on. So now, if the prosecutor is involved, it is he who should say whether the case is fit to be charge sheeted or further investigation is required. He should also be in a position to advise if an acquitted case is fit to be taken in appeal or not. Today, it entirely depends on the police. The director should also have powers to permit the complainant to engage his own lawyer to assist the public prosecutor. That is not there in the law now. But I understand this is a very common practice in France. You can have your own lawyer in addition to the public prosecutor. And this is Malimat also, Justice Malimat also recommended this. In a position to advise if an acquitted case is fit to be taken on appeal or not, the director should also have powers to permit complainant to engage his own lawyer and to assist the prosecutor. All this would be possible only if the department is well established and enabled to cooperate, to coordinate with the investigators and courts. Plea bargaining. This is another thing again, they brought in plea bargaining, but very briefly mentioned. The code puts emphasis on plea bargaining. Presently, the initiative vests with the accused to negotiate with the prosecution. Once an offense is found to be fit for plea bargaining, it should be made obligatory for the courts to give notices to both the parties about this provision and fix a time limit within which they should come forward. That is, according to the law, the complainant or whatever it is, the accused should approach the court. I am suggesting this responsibility should be put on the court. Court should say this is a fit case for plea bargaining. You file your thing within 30 days or something. The proposal, in other words, the court should take the initiative and persuade people to take this alternate dispute resolution mechanism. Victim compensation, the most important thing. They say the victim is a victim of an offense is twice hurt. First by the accused and a second time by the law itself. The law is so much against him. The whole thing is weighted against the victim and weighted in favor of the accused, which is obsessed with the rights of the accused at the cost of the victim. Victimology was a subject of much interest to Sri Venugopal Rao. He spoke and wrote extensively on this towards the end of his life. BNSS makes extensive provisions in sections 395 and 396 for compensating the victim, which is a welcome development. Section 400 extends it to even non-cognizable cases also. But the question is to have funds. Funds should be, unless they permit the courts to retain the funds, fine funds with the funds which they collect by way of fines in a, with the court and legal services authority. If they depend on the government for money, it will never come. Previous government of Andhra Pradesh, Hyderabad Study Circle, you have mentioned, sir. It's a small organization. It runs on a shoestring budget. The previous government owes us 1.5 crores even now. They sent candidates, we trained them, and they didn't pay for it. Not only me, several people. So if you depend on the government for witness compensation, it will never come. So you have, the funds should be at the disposal of the judges. Witness protection scheme. Section 398 lays down that every state government shall prepare a witness protection scheme. Witness the victim compensation, witness protection. The responsibility of the state governments to make this, to ground these two things. We will have to take it up. The police department has to initiate the proposal. In both the cases, that is victim compensation and witness protection, the state governments are expected to formulate the schemes and put them in place. The schemes would be worked by the District Legal Services Authority, who in consultation with the State Legal Services Authority will decide on the amount of compensation and witness support. These schemes will work well only if the entire fine amount or the best part of it is credited to a fund created for this purpose at the disposal of the Legal Services Authority. The government should also contribute to it. If the government alone are to provide funds, this scheme will not work smoothly. This is our experience. No, ultimately they will say there are no funds available. Institution of executive magistrates. The hierarchy of executive magistrates is a typical colonial relic. It is surprising that it is still retained in this revised CRPC also. The executive magistrate thing is there. BNSS has a provision to devolve magisterial powers on police officers. Incidentally, now Orissa government has declared all the police officers as magistrates already. Oh, this is I didn't know this. above the rank of superintendents of police for day-to-day functioning. The state of Odisha has already invested all the magisterial powers. They say, Kamal says it has been withdrawn. But there is no need to retain a cadre of officers as executive magistrates. The executive functions can be added to those of judicial magistrates. It is time this colonial institution, which is now irrelevant, is wound up. The Malimat committee suggested many useful amendments to some of the sections of the procedural law to expedite trials. BNSS would have been in a much better document if they were incorporated. Many of them, he has made section by section, he has analyzed, and he has also suggested how it should be amended. Instead of taking advantage of that, these people are using their wisdom or knowledge or whatever it is, creating further confusion. Now, status of the investigating officer. In the eye of the new law, the investigating officer is as suspect as he was all these years. He is still a suspect. Confessions made to a police officer of any rank is not admissible as evidence against the person making it. So is the confession made by a person in custody. As before, any fact or object discovered consequent to the statement of a person in custody is relevant evidence. The suspicion that runs against the police in the CGS is obvious. We cannot work a system effectively if the principal enforcement agency is suspect in the eye of the law. Principal agency is suspect. It is suspect. The law itself doesn't trust the police. Why should people trust? There is no sense in distrusting the police as an institution. If all is not well with that institution, effort should be made to improve it rather than castigate it, which would only further weaken it. Now, correctional services, a very important thing, unfortunately, most neglected thing also. The fourth pillar of the CJS is the much neglected correctional administration. The primary goal of CJS would be to facilitate offenders to reintegrate into the society as law-abiding citizens. Some interventions to achieve this goal include cognitive behavioral therapy to address negative thinking and behavior, educational and vocational training to convicts to provide practical skills, restorative justice practices which involve repairing harm and promoting reconciliation. This is a very technical thing. We need to have a separate department with the consultants, particularly psychologists, and they have to work together to do this. Social welfare department cannot do this. The approach shifts from punitive mindset to the one that prioritizes rehabilitation of young offenders. It's a huge responsibility and needs well-trained professionals to manage. Presently, Social Welfare Department is charged with this responsibility. It's one of the numerous schemes this overburdened department works. Though administratively part of the Social Welfare Department, it is important the officers concerned with this work, they should work in close cooperation with the police department. It would give them better leverage to function effectively. It would at the same time make the police officers sensitive to their reformative responsibilities. So, for example, now let us say many of them are young offenders who are in their early 20s, that kind of thing. Suppose there's a separate department with a police officer at the head of it. Maybe we can recruit them as home guards, keep them as home guards, and let us see for some time whether he improves, whether he takes interest in work. Maybe we can train them, we can sell them to a skill development center and train them in this thing. Home guards, yes, we can watch them. We can tell our people, it is a man we are trying to rehabilitate, you watch out. So it will be very useful if they really do this department, organize this department and take it seriously. Now, what should we do in the days to come? The way forward. Some time ago, Government of India appointed a committee to evolve a policy for criminal justice reforms. I think in 2007 or so. Mr. Shivaraj. He was the Home Minister, he appointed a committee with Madhav Menon as chairperson and our Kamal Kumar as one of the members. as director NPA. The committee has done a great job in bringing to our notice both the requirements of international law and the national priorities. How do you build these things into the what do you call our law, into our law? A police framework for the CJS. Government of India may consider approving this and making it a template for the evolution of CGS. Now we have this crime investigation department, third police commission, police commission, national police commission. Everybody has recommended, even I think our Padmanabhai committee, what they have recommended, investigation should be separated from order keeping functions. And investigation should be a separate department. It should have nothing to do with it. Now what's happening even now, whenever there is an agitation or Ganesh thing, all officers investigating cases are drafted for bandobast. Cases are neglected. It should be a separate establishment altogether. Otherwise, it won't receive the attention it deserves. They recommended this. Third Police Commission recommended there should be what is called State Security Commission, on which both the ruling party and the opposition parties are represented. For obvious reasons, this has not been implemented. Now, you see, they have retained the police under the control of the government, not under the control of a neutral agency, which was the recommendation of several commissions. So you have, when Jagan is in power, Chandrababu is inside. When Chandrababu is in power, Jagan would be inside. This is going on. How do you remedy the situation? It might happen in Telangana also. So, and for a long time in Tamil Nadu, there was DMK police and ADMK police. And Jayalalitha, I remember when she was became the chief minister, she insisted Karunanidhi should be put in the same cell where she was put when she was in opposition. So this is how police is being misused. And people say police should improve. How can it improve? You have subordinated it to the government, to the executive. He has no way. He has to carry out the orders to the government. Now, several officers are in jail now in Andhra, including police officers. Where what I am suggesting is a via media. It should be possible. We should be able to persuade the state government to separate the investigating wing of the police from the CID from the order keeping wing of the police and making it accountable to a neutral agency. If the entire police force, if it is not possible to make it accountable to a neutral agency, at least the investigation part of it, you have CID, you have Vigilance Cell, you have Anti-Corruption Bureau. At least these things can be brought under a separate and neutral agency in which both opposition and ruling parties are represented. Now, crime without borders. Modern day crimes, particularly cyber crimes, economic crimes and cyber crimes, they don't know borders. Now you are still governed by the old thing, that state police has jurisdiction only within that state. There are no borders. Economic offenses, corporate and stock exchange frauds are also crimes without borders. A case may be registered in Hyderabad. The accused may have operated from a place thousands of kilometers away. Many cases registered in Hyderabad, accused were in Kota, Rajasthan, and some other Assam, someplace. And some of them outside the country also. Cambodia. We need a federal or central investigating agency which has branches in all the states, and there is dire need for a central law and a central agency. Now they say police is a state subject. Whether it is state subject or whatever subject it is, a law is required. How do you bring it? We have to think about it. So I suggested a Model Police Act. Union government has responsibility to compel the states to bring in new police acts, notwithstanding the fact that the police is in the state list. The new act should also provide for the central investigating agencies to function on their own. Suppose there is a provision in the new police act saying central investigating agencies, they can function. It is possible to put it. If it is not possible, then the only other alternative is amending the constitution. But there is already NIA. NIA, they have given permission, National Investigating Agency for these terrorist offenses. They have given permission to operate So similarly, we should attempt for these cases, at least for the crime case, cyber crime and economic crimes, we should have that kind of facility. Otherwise, it's impossible to investigate these cases. The new act should also provide for central investigating agencies to function on their own, not at the mercy of the states. An enabling provision can be a part of the act. We can make a provision, enabling provision. We have a precedent in the NIA. If it still requires an amendment to the Constitution, so be it. You have to amend it. There is no other way. Accountability. Any system is as good as the people who work it. Unless the people involved are accountable at appropriate levels, things do not improve. In the criminal justice system, both the police and prosecutors are to be held responsible for good results, as is done in the CBI. CBI, both police officers and the prosecutor is also held responsible. And then we have our courts with all the autonomy in the world, but not accountability. They should go beyond finding fault with police and assume the responsibility of finding out the truth. For a long time, Ramohan Rao Garu was advocating, you cannot say beyond the shadow of doubt. You must go by the probability of circumstances and other evidence. You should be able to continue, but they won't. They won't. Malimat, I'm reading out what he said. The court shall at any stage of any inquiry, trial or other proceedings under the code summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined as it appears necessary for discovering the truth in the case. This is what Malimat said. He says, you should put the responsibility of finding out the truth on the court itself, not only in the police all the time. All these things perhaps require amendment to the Constitution, but they will have to, your so-called adversarial system has to be blended with the inquisitorial system. There is a justifiable criticism that CJS is centered around the accused, ignoring the victim for whom the system perpetually exists and is supposedly operating. This is what that policy, our Madhav Menon committee has said. The UN has also acknowledged this indifference to victims of crime and called upon member states to amend their laws, giving special rights to victims to participate in criminal proceedings. Now today it's all left to the public prosecutor. We should be able to have our own lawyers in addition to public prosecutor, and to claim compensation irrespective of the outcome of the criminal case. Even if a case is acquitted, still he should be able to claim compensation. The Committee on Criminal Justice Reforms 2003 recommended empowering the victims of serious offenses with the right to implead themselves as a party, right to be represented by counsel, right to produce independent evidence, cross-examining witnesses with leave of the court, right to be heard in the matter of bail, right to continue with the case even if the prosecution even if prosecution wants to withdraw the case, he should have a right to continue with it. The victim should have a right to prefer an appeal against an adverse order. The state should also ensure rehabilitation of hapless victims and victims of crime and violence. This is 2003 CJS Reforms Committee, Madhav Menon Committee. They have both recommended these rights have to be created for the complainant. Now, this adversarial system versus inquisitorial system. Though our CGS functions an adversarial system, which insists on proving the guilt of an accused person beyond the shadow of doubt. And the benefit of doubt always goes to the accused person. In this system, the interests of the accused are zealously protected, often at the cost of the victim. Whereas in inquisitorial system, the court takes an active part in the proceedings and can order further investigation. Ideally, combining the best features of the two systems would go a long way in arriving at the truth. In respect of economic offenses and cyber crimes, the burden of proving the innocence should be shifted to the accused. Once it's a terrorist offense, it has been shifted. Suppose once you realize it's a terrorist offense, the burden of proving his innocence, it lies with the accused. Should be done in respect of economic crimes and also cyber crimes. Decriminalization of offenses. An effort should be made to decriminalize offenses involving marital problems. Why should they come to the police? Police again sending them to, what do you call that, marriage counselors. Because so this is the policy, one of the points referred by that policy, Madhav Menon's recommendations. Marital problems, domestic violence, civil rights. Separate tribunals can be created for this purpose. They need not come to the police for everything. Now, review of the law governing CJS. It is necessary to have a standing committee in the Union Home Ministry to review the CJS every 5 years. For example, so many judgments are coming. People to ordinary sub-inspector does not know what is happening. So many things, the law has to be amended from time to time. You see, in 100 and odd years, we have amended it now. Every 5 years, we have to look into the CRPC, Evidence Act and all that. From time to time, if it is amendments are carried out, it will be a much easier job. And not law commission, concerned administrative department. In fact, I went to the law commission for CRPC amendments. They told me, no, it is not our responsibility. Home Ministry should move the file. That is, these quinquennial reviews should be guided by criminal justice policy. Now, policy has to be stabilized, and these reviews should be in line with the policy and should involve the stakeholders in the system, namely investigating officers, prosecutors, and judges who work these laws while in service and arrive at the amendments to be in court. They have to look into this, whether these things are workable or not. Every 5 years, we'll have to constitute a small committee. They have to look into this, and then they should recommend what amendments are required. For the present, Home Ministry would do well to move for a comprehensive amendment of BNSS based on Malimat Committee recommendations. Now, this can be taken up straight away by the states. Already it is there. In fact, CRPC can be locally amended also. If it is, what can be amended locally, we can amend it. Rest of the things, we should take it up with the government. Now, I'm coming to the end of the talk. You will be surprised to know we have 359 million criminal cases pending in courts. 359 million. Out of them, 80% are in the district courts. 75% or so, district courts and below. The figure primarily represents cases in district and taluk courts, as well as high courts. As on 15th September 2025, the Supreme Court of India has a total of 18,864 criminal cases pending disposal. Supreme Court. And some of them are 30 years old. India faces a challenge with a large backlog of cases, and criminal cases contribute significantly to this backlog, with over 80% of all pending cases being criminal cases. If you take both civil and criminal cases, pendency is almost 500 million, that is 50 crores cases. Today, the more cases are being instituted than disputed. So they should find a way of sorting it out. Somebody should think about it. 80% of there is a good case for a separate hierarchy of criminal courts. We need to have separate hierarchy because most of the cases are criminal cases only. 70% or 80% of them are criminal cases. And we should take to this, what do you call that, alternate dispute resolution mechanism. This kind of thing. Some way should be found. Otherwise, we can just, if you ignore like this, I mean, it's going to create a situation where people will lose faith in legal justice. Even now, as it is, people say. Yes, yeah. So this is what all I have to say. I'm happy. At least, this victim compensation, a thing which was very dear to the heart of Venugopal Rao Garu, found place in CRPC. Now, our DG has to write to the government to create this fund. Whatever name they call it. We have to see, it is our responsibility. Now, for this and witness support for both things, we will have to take it up with the government, and then they have to create some fund. But now there is a chance of a lot of money collecting because fines are very stiff now. 10,000, 15,000, 50,000, 20,000 like that, Judges, in fact, we should even negotiate with the government saying, give a matching grant. Suppose we realize some 20 lakhs, let us say, by way of fine, government should give at least the other 20 lakhs. So that's how it is. It's a very unhappy situation. That's why, some time ago, there was a case where people involved in a rape case were shot dead. And then there was a committee appointed by Government of India. Why is it happening? And when these people were shot dead, local people started, throwing flowers on police and all that, They were happy that, such a thing has happened. That is because things are not being decided in time. People have lost faith that cases would ever enter in conviction. So this is a dangerous situation. It may lead to loss of faith in the courts. And it can lead, again, the same, see, Naxalism also started like that in Telangana. When I was SP Medak district, I found in Siddipet port, there were no civil disputes pending. All disputes were withdrawn. I asked them, how is it, they said, sir, no, most of these people have gone to Naxalites, they have settled the issue. No. So that is how Naxalites became popular, because they used to dispense justice then and there. And that's how the game down in Telangana. So if it goes on like this kind of lawlessness, there's a good, there'll be a good chance, that the entire country will suffer. Thank you, sir.
Now I would request our chairman to present a memento to our chief guest who delivered the oration. I would request Dr. Vyasanarayan Rao to give the vote of thanks on behalf of the family of Mr. Venugopal Rao.
Good evening to all of you. It's my pleasant duty to propose a vote of thanks on behalf of family of Professor Venugopal Rao. I am his son-in-law. I work as a senior urologist surgeon here in the city. At the outset, I would like to thank Sri Anjaneyya Reddy Garu for a very informative and well-researched oration on the police reforms. It was very informative, and we enjoyed this oration. Thank you very much for sparing your time and being with us this evening. Dr. Sri Anjaneyya Reddy Garu and late Venugopal Rao had excellent rapport. They had mutual friendship and regard with one another. I used to remember very often Sri Reddy Garu would visit Venugopal Rao's residence in Banjara Hills. They would spend many hours in the evening talking about police force reforms and research and development. They had that affinity. They were both cerebral police officers. Because of his initiation, he became the emeritus professor in Police Academy and used to deliver lectures in AP Police Academy. Therefore, thank you very much once again for your very interesting oration. After the demise of my Mr. Venugopal Rao, we, the family members, decided that we should do some activity in his memory. Therefore, we have created a memorial trust. As part of these activities, we decided to have yearly orations in his memory. These orations to be delivered by senior police officers, well-respected and well-respected judiciary. This is sixth such oration. When this idea came to us, we met Sri Padmanabha Garu, Chairman of Administrative Staff College, put forward this idea, requested whether we could have these orations under the auspices of this college. We felt very happy that he immediately agreed, and that's how these orations are being held. We thank you for your commitment and help in this regard. I also want to thank Mr. Ramesh Kumar Garu and all the staff of Administrative Staff College for your dedication and help in this regard. Last but not the least, I want to thank all of you, including the senior police officers who spared their time this evening. Thank you one and all for being with us. Thank you very much.